The Pregnant Workers Fairness Act was passed in 2023 to expand federal law to provide reasonable accommodations for pregnant workers. Under the Act, limitations related to pregnancy, childbirth, or medical conditions related to childbirth must be accommodated unless the accommodation would cause employers an undue hardship. The PWFA is landmark legislation that allows more pregnant workers to remain employed before and after childbirth. This law applies only to accommodations. The EEOC covers other laws that make it illegal to discriminate against pregnant workers. The PWFA does not replace federal, state, or local laws that are more protective of workers. The PWFA protects employees who work for private and public sector employers with 15 or more employees, federal government agencies, Congress, labor organizations, and employment agencies. Reasonable accommodations are changes to work policies or the way things are done at work. Some accommodations include providing more opportunities to sit, providing more opportunities to eat or drink, assigning parking spots closer to work, scheduling flexible work hours, allowing time off for pre- and postnatal medical appointments, providing correctly sized uniforms and safety apparel, allowing additional bathroom breaks, offering leave or time off to recover from childbirth, assigning less physically demanding activities, assigning tasks without exposure to substances unsafe for pregnancy. Employers are required to provide reasonable accommodations unless they would cause an undue hardship on their operations. Undue hardships are significantly difficult or expensive situations that result from an accommodation. However, undue hardships are rare. Most accommodations are easy to implement and not very expensive. Employers accountable by the PWFA must not make accommodations without first having a discussion with the affected employee, refuse to hire or offer employment opportunities to qualified workers to avoid providing accommodations, require an employee to take leave when there are reasonable accommodations available that would allow the employee to keep working, retaliate against a worker for reporting or opposing unlawful discrimination or participating in investigations or other proceedings under the Act, or interfering with employee rights under the Act. Workers affected by pregnancy, childbirth, or related medical conditions are also protected by Title VII of the Civil Rights Act of 1964, the Americans with Disabilities Act, the Family and Medical Leave Act, and the PUMP Act. Under these laws, employees are protected against harassment and discrimination, provided with unpaid job-protected medical leave, provided with reasonable accommodations for some pregnancy-related medical conditions, given protections to express breast milk at work. The Pregnant Workers Fairness Act requires that pregnant workers be treated with dignity and respect in the workplace. The landmark legislation will allow workers to remain on the job during and after pregnancy and get the accommodations they need without fear of discrimination. Employers who follow the law will stay out of legal jeopardy and retain more of their most valuable resources, their employees.